Good morning, everyone. Sorry, I had to mute in the background so that way we don't have an echo. Hopefully, things go smoothly today. It sounds like it's going to be the last day. And then, but of course, we know that Bamita is going to be doing the questioning today, and we know how quickly she gets through that. So, I don't know. I was thinking like a half day, but we'll see. So, yeah, good morning, Misty. Good morning, Ruth. Good morning, Susie. Good morning, Lucille. CBS 8 does not even have their stream up yet, so just waiting. I'm just gonna shower when I get back from running Jada. Oh, lovely. You guys probably heard that too, since I'm not muted.
Hear you when the heat's running. I'm downstairs.
Yeah, clearly I need to learn how to use a mute button, right? But yeah, I saw that there was that live with Biden. I don't know if that's going to mess things up. Okay, let me jump over, Lucy. Hold tight. So yeah, I'm not finding any streams right now. I'm toggling between both 10 News and CBS 8 to see if they're streaming, and I'm not finding it anywhere yet. I don't know if they just aren't turning on the cameras for us yet or what, but I'm watching, so hold tight, guys. Yay! Thank you for that update. I appreciate it because I've been following CBS 8 and they've been pretty consistent, and I was seeing nothing, so I appreciate it. If I were the judge, I'd be calling a meeting like, let's just go to trial. I've heard enough. But of course, I'm not a judge. I'd be getting paid a lot more if I was, probably. So while we're waiting, last night I was just watching the groups and I saw that there was a post in one of the groups saying that it was this. Actually, it wasn't even a post. It was a post in the group of a screenshot from NBC 7 San Diego, and the comment said, "I called the hotline and told them that on the morning of January 8th or 9th, I was driving through Mount Laguna, the turnoff from Julian to Laguna, and I saw the very same black SUV shown on TV news on my left at a hiking area. For anyone to be out in the sunrise sitting there was strange. Later the same day, I drove back from Mount Laguna, and the same large black SUV was at the other turnout with the bathroom rest area. I thought, what is a person doing out there? Because I remember seeing a child near the vehicle at sunrise, and it's 7 hours later. I think he dumped her body parts all over Mount Laguna. Now, obviously, you see comments like this that pop up. Yeah, see, you guys saw it. And that really kind of took my breath away because I think it's sadly a possibility. The comment itself was pretty graphic, but I really hope that if he genuinely saw Larry that day, that he did call the tip line and they are able to find her. Oh, you found pictures of Jamie? He is not. Oh, great. Darn it. I mean, I guess the judge could possibly say that. I'm not sure. I was thinking more along the lines that he's going to say we're going to trial and that Larry needs to find him some effective counsel if he's going to keep trying to defend himself. That or else he should just tell the truth and tell where May is. Yeah, that's what's frustrating in a lot of these cases. You get a ton of people that come out of the woodwork with all kinds of stories, and whether they're true or fabricated, it's really hard to distinguish between sometimes. And so, um, I don't know. Just hopefully at some point, one of those tips that comes through is a real tip that will find her. Me too, girl. Me too. Stop it. He does not have a handlebar mustache. Quit that. If you want, you can email it to me. I'm curious. Actually, just, well, I don't know. I don't know if you should post them. It's not very nice. Poor guy. He would, I don't think May would want us to do that, right? Probably not. Doesn't mean I'm not curious, though. And you're right. He did treat her well. That's important.
So I was hoping that the news is going to stream it still today. That was my understanding, but from what everyone is saying, it sounds like they are in some sort of a meeting, sidebar situation. Normally, even on like the news website, there's usually a stream link running right across the top of the page, and today that's not there. So I could not tell you what's going on. I mean, honestly, I'm glad that he worked things out with his wife. I I said this to a friend of mine. I don't think that it was ever meant for May to have a man that was already with somebody else. I think she was much more deserving of something more. I think what a lot of people are failing to see when they want to shame May for the affair is the fact that she was being abused and she was alone and isolated and broken, and someone came into her mess and actually cared enough to hear her and be there for her. And I'm so glad that he did. I by all means, I don't think that it's at all acceptable that he engaged in an affair with her when he was married and his wife was pregnant with a baby. But let's keep it real, like he did help to restore some sort of like confidence within her that she was valuable and she mattered. And so anyway, I feel badly for her that she was ready to leave, and she was ready to do it without jumping into another relationship. It doesn't sound like that was what her goal was at all. She just wanted to be a good mom. She wanted to go hiking, she wanted to hang out with her friends and live her life, and without all of the madness that was going on inside of her own home. Here's the thing. I don't blame Larry for calling this guy's wife. I mean, if you love someone and they're your spouse and you find out they're having an affair, you might call the other person's wife. All of those things are normal circumstances if there's an affair happening. I mean, affairs happen all the time. And you contact the other person, or you contact the significant other, or you contact their family or friends because, you're digging to find the truth. And he probably wanted to know the truth. But at the same time, he was unwilling to accept what was going on and either fix the marriage in a healthy way, which he might have even had a chance to do if he wouldn't have been acting crazy and doing all the things he was doing. He needed to let her go. He needed to, let her be free to make her choice of what she wanted to do. And he wasn't doing that. And so, I mean, I don't blame him for calling the wife whatsoever. What I blame him for is acting like a crazy person. I mean, sadly, I have to be honest. I think it's a miracle that both Jamie and his wife are alive, because it seems like he was not in a good space, and he potentially could have hurt other people, not just May. And that's just my opinion. Oh, and Larry's mom is just an enabler. I'm so sick of hearing about how his parents are this and that and the other. I mean, I feel bad for them too, because in many ways they're victims of this. But come on, you are literally in denial about your own son and enable his BS. I'm so over them. I think that the reason that she wasn't in love with him was because he wasn't being the guy that she met. I mean, you don't fall in love with someone because they're doing all kinds of crazy things, putting subliminal messaging, in speakers around your house, and, you know, possibly potentially poisoning you, sedating you, or putting spells on you. Those things aren't, that's not what she fell in love with. And, I maybe she was tempted. Maybe that other relationship was tempting, and maybe she was falling into some things. Everybody's got faults. That does not mean whatsoever that the way he handled this was normal. Something is very, very, very wrong with all the things that he was doing leading up until the day that she went quote unquote missing. And you're right. 20 years will change a lot in a message in a marriage. It's so hard. Oh, okay, hold up. Okay, camera's not on yet, so I'm just watching. I just, I firsthand have been through a lot of really hard things in marriage, and I've been on the receiving end of some terrible things, and never would that have ever enticed me to go and try to force said person to be with me. I think he's got some serious troubles. um, this wasn't about what May was doing. This was about him and what was going on with inside himself. So I think the reason that I get the delay in starting the stream is because they let everyone get into court, everyone get down and settled. They allow court to start, and they delay before they're going to hit start on the camera that I'm streaming from. Yep, marriage is a choice that you have to make every day. And some days you're really not in it. And that's what it's called a partnership for, because hopefully the days that you're checked out, your partner won't be, and they'll love you through that space. And I mean, love you through it in a healthy way. I mean, I'm not trying to say that Larry and May could have saved their marriage, but I'm saying maybe their marriage could have been saved if he would have been worth saving, but he was not doing right by her. She had every reason to be um, running out of that marriage. I don't blame her a bit. I'm cringing watching the testimony the last couple days, thinking what her life was like. Could you imagine walking on eggshells, wondering if you're being listened to and watched and followed? Like, she probably couldn't breathe or sneeze or do anything. I mean, I wouldn't even be able to use the bathroom comfortably. I'd be checking my shower. I feel so bad for what she was living through. Thanks. I have not heard that before. I have a bit of a phone voice because I spent years working on the phones. And so, yeah, I'm used to talking to people. She was tortured in the worst ways. Hey guys, let me jump over and try the other stream, so hold tight for me. Okay, good, because for some reason it's not allowing me to toggle over to the other stream. Hold tight, guys. I really believe that marriage is for a lifetime too, but I mean, there are things in marriage that sometimes are a no go, and sometimes things don't work. Some people split up and they make it back together. Some people are happier after they've moved on. Um, some people stay married, and all of that is okay. All of that is okay. What's not okay is doing something that destroys the lives of everyone around you because you can't accept something that's going on in your relationship, whether that's abusing your spouse, whether that's harming their friends and family or alienating them, or, you know, even having affairs. You really should not have an affair because you're unhappy in your marriage. But you know what? Those are all things that you can get therapy for and get help for. But guess what? He can't come back from this. May has not come home, and there's no going back on this. And so he ruined everybody's lives, and especially his children's lives. Yeah, everyone, we're waiting for them to start back in court. They've been meeting all this morning. I'm getting a feeling that this is not going to go long. They're probably making some decisions behind the scenes, so hopefully soon they'll start.
And the parties have asked the court to prepare redacted versions of any exhibits for the purpose of protecting privacy of minors and any adults, so personal information. So we're going to redact certain exhibits, and the media is aware that there's a policy that they have to adhere to if they are requesting any exhibits. Any exhibits that are provided to the media will be redacted to protect the privacy of adults and minors. And there's a request in regards to the CPO, the criminal protective order, and the contact that the defendant has had with his children. We'll address that at a later date. Yes, sir.
Your Honor, David Gottfredson with CBS 8. Could the media be heard on the redaction order, maybe following the preliminary hearing?
Yes.
Thank you, Your Honor.
Okay, Mr. Rhodes is on the stand. You've completed your direct examination.
Yes.
All right, then you may be.
Thank you, Your Honor. Mr. Rhodes. Ask you about the financial history and accounting that you tested yesterday to the Millete accounts. You looked at Ms. Millete's accounts at NFCU.
Correct.
And you testified that she did have a checking account under her name alone. In addition to that, she had a savings account under her name alone.
So for their account, they had joint accounts, and each of them had an individual checking and savings underneath that broad account. Yes.
Yes, so they do have joint savings account
Correct.
and a joint savings account. Okay, so that means that Ms. Millete was able to withdraw money from those accounts if she wanted to.
Well, you don't. If she were to go into a bank and request withdrawal from a savings account, she was listed as a joint user on the savings account. Yes.
And she would have the ability to withdraw money from that account without the permission of Mr. Millete.
That'd be correct.
And isn't it true that Ms. Millete was claiming she did not have access to any of their money?
I can't testify to the accuracy of what Mrs. Millete was speaking to, as I did not personally speak to her. I can only testify to what the data in the record shows.
Did you discover that Ms. Millete's salary from NIWIC was deposited into that joint checking account and savings account?
It appeared that prior to the March 26, 2020, April 2020 time period, that the deposit went into their checking account, and then after that, it appears to have gone into their savings account.
Did you have information to believe that Ms. Millete intended to deposit her entire salary into those accounts during those days that you mentioned?
I'm not sure I understand what you mean by what she intended.
In order for her salary to be deposited into those accounts, would it be Ms. Millete to request her employer to deposit those monies into those savings accounts?
I think you would have to speak to her employers about their process.
Okay. She also could, I think she also received statements from those accounts from NFCU, correct?
I don't have any personal knowledge of what statements she received.
You reviewed some of the bank statements from NFCU in 2020 up to, I believe, January 30, 2021.
It was a little past January 2021, yes.
Okay. And those were statements addressed to both Mr. and Mrs. Millete, correct?
The records I looked at were obtained via search warrant, so they came to general.
So you get the statements that was sent to them?
credit.
Your review of those records, were you able to determine whether Ms. Millete withdrew money from those accounts
Vague is the time.
during the time frame of 2020 to 2021, or maybe past January 2021? Were you able to obtain information that Ms. Millete withdrew money from the savings account?
I don't recall any significant money. Again, the trend being in 2020 that money was removed from her independent accounts and money was moved from their joint checking into Mr. Milliete's independent account. That was the trend throughout the year.
Could you tell if it was Ms. Millete who transferred those funds from Mrs. Millete into Mr. Millete's account?
I was not present, so I would not be able to tell you who performed the action.
Did she have any ATM withdrawals, things like that, purchases after the March date?
That's kind of, there's different answers there, Your Honor. She had a credit card as well. And are you asking, did she have any ATM withdrawals from her, the joint account?
Yes.
I believe there were a couple $20 withdrawals here and there, but there was no significant amount of money withdrawn.
Was there any drastic change in that account on or about January 7, 2021?
Which account are you referring to?
The saving accounts from NFCU.
There's activity. I'm not sure exactly what you're referring to as far as drastic changes.
Such as a huge withdrawal, perhaps $70,000.
From Mr. Milliete's account?
Yes.
I would have to look at the specifics, but there is money withdrawn from Mr. Milliete's account at the end of January and I believe also in February of 2021.
Do you recall those amounts?
I would have to look at the specifics to recall the amounts. I can tell you that from January 2020 through beginning of February 2021, that just from his independent accounts, there was in excess of $50,000 withdrawn.
Any other big withdrawals in those accounts?
I mean, I'd have to go through the itemized list in order to give you specifics on the dates of withdrawals.
Would they be around the January 2021 timeframe?
The ones of note were at the end of January and beginning of February 2021.
And you don't know.
I'm object vague as to which account, because there's been discussion of joint and independent accounts, and it's unclear to me
Let me clarify that.
what we're talking about.
Well, Mr. Rhodes, you can also clear that up.
Right. I'm specifically referring to Mr. Milliete's independent account for all these statements.
Were you aware that Ms. Millete withdrew a huge amount in her TSP during 2020?
I believe that's misstating the information. That's a completely different. We can.
So let's clear it up.
He said he doesn't.
Well, I would object to beyond the scope of foundation. I think she just foundation for what TSP is.
I think let's get it all out on the record. I want to know.
So this would be prior to 2020, and it appeared to be. And again, I'm just going off of my memory here. It was not something that, after looking at it the first time, was any significance. It appeared to be maybe money used for mortgage or a car payment. There was some purpose for it, which I can't recall off the top of my head, but it was accounted for as for what the purpose was.
What does TSP stand?
That's going to be basically the retirement or savings account for the military, for her NIWIC and SWORMAC accounts.
And you said that you were aware of that withdrawal
Correct.
in 2019.
It could have been even before that. It was before 2020.
And why do you believe that the money was traced to a source that you're?
I can't recall off the top of my head. I know I thoroughly went down this rabbit hole with that amount, and that's what it came out to be. I have it. I went down this road documenting what it was, but it ended up being something that appeared to be a joint usage between the two of them.
Thank you.
Do you know if there was a significant balance left on the card, on Miss Milete's card, in order for her to make purchases?
Which card are you referring to?
I believe you testified Barclay?
The Barclays card, which was recovered on October 19th, 2021.
Yes.
So that had about 14,600 worth of credit. I believe 2,000-ish was owed on it. So about 12,000 was still available.
I believe you testified that she had 6 credit cards.
I don't believe I testified to that.
Do you know if she had other credit cards that were available for her to withdraw?
She, per her credit reports, did not have other credit cards that were open.
Would that be in the year 2021?
At the referring to, did she have 6 open credit cards at January 7th, 2021?
Right.
She had her Navy Federal Credit Union card and the Barclays card that were active at that time.
Was the Hawaiian Airlines credit card the same as the Barclays credit card, if you know?
That would be correct.
Isn't it also true that in 2020, elects friends,
Objection calls for hearsay and vague, lack of foundation.
Right. Let's stand on all those grounds. I've heard from other witnesses. I don't know. Mr. Rhodes did not testify to that.
I believe Mr. Rose interviewed those witnesses, and one of those witnesses informed him about the fact that she observed Ms. Millete's using cash quite a bit in 2020.
If that is the case, you may refer to the exact witness who he interviewed in that regard.
Did you interview Miss Alison Balcony? Alison Balcony.
Point me to.
I am reviewing my notes from yesterday afternoon regarding Mr. Rhodes' direct examination. And it focused on the electronic evidence to a very large extent, and not in interviews that he conducted with anyone other than
Okay.
perhaps the neighbor.
And
Yes.
I don't believe there's going to be a report because I don't believe there was an interview with this witness.
Okay.
I just want
All right,
to short circuit
so-
this
Okay.
search.
Okay.
Okay.
Then it's outside the scope of
Okay.
direct
I'll move
examination.
on, Your Honor.
You also investigated the Millete's crypto account.
Talking about Mr. Milliete's crypto account.
Is Miss Millete not included in the crypto account?
There was no subscriber information for her listed.
Okay. And were you able to discover all of Mr. Millete's cryptocurrency accounts?
I don't know. There might be something I missed.
How many cryptocurrencies did you discover that belongs to Mr. Millete in 2021?
He had, that I was able to locate, 2 subscriptions. One was to Coinbase, which had the most amount of money in it. And there was a second one, which I'm not sure that money was actually going into, but had been subscribed to. I can't recall the name of that one off the top of my head.
Your report states that per Coinbase, Larry has spent or deposited an approximate amount of $90,622 into his Coinbase account. Do you recall your report?
I would have to review my report for the specifics. However, I know that there is money that went into the account prior to 2020.
Would that be in 2019?
I would have to look at the specifics, but if my report states he deposited $90,000 into the account, then that would be accurate if that's what my report reflects.
Counsel, again, he's got his report, and if you refer him to the page of his report, that will refresh his recollection.
Let me
Otherwise,
refer.
I don't think it's fair to throw out questions like that. You can refer to the report, and you're not a witness to it.
Let me refer him to the page number, Your Honor, of his report. D01581.
Can you give me what my report is titled and the page on my report?
The report is, it says case, parentheses, PRE, dash issue, close the parentheses. And it's page 5 of 7.
Would this be my Coinbase report?
I believe it's Coinbase. And it's D01570.
On this one, I do, but it's not an easy method for me to review my report. I believe I've located my Coinbase report. So there's a specific portion of my Coinbase report we need to look at.
In page 1 report on May 20, 2021. And that Mr. Millete created this Coinbase account April 14, 2019, using his name.
I don't think there's anything. You need to just tell him the page Maybe you can approach him
Okay,
and
yeah.
show him what you're looking at, but
Can I approach her?
you may.
Page 3.
Is this based on 15?
Page 150.
Page 5.
He is super irritated, isn't he?
Does this report start on 15?
Yes, he's got it. Thank you.
What's your report dated?
As far as the date that it was approved,
Whatever you want to use. Written, approved, identifying information for.
it'd be August 20th.
Yeah.
This didn't know. It's just my investigative report.
Yes,
I'm just
I just move on, Rhonda. In your investigation, Mr. Millete provided this information to Mrs. Millete, correct?
I have no knowledge of that. Would you be able to point me to where any of that information is?
That's fine. Okay, well, let me call your attention to, I believe, to this incident where Miss Millete's neighbor, I think it's Miss Trudeau, Heather Trudeau, that you spoke to and reported some big blast or some noise in close to the Millete residence. Do you recall that incident?
I recall the incident, yes.
And that happened around 2020?
That would be inaccurate.
When did that happen?
Are you referring to when I spoke to her or when the fire incident happened?
A real fire incident? Fire.
Well, the fire.
Okay. In the, I believe in the video, did you actually see a fire?
I mean, we watched the video. You can see a large blast of light, 3 seconds approximately to the video.
Okay. But there was fire. I think the video only shows light. So I would like to.
I think you're convoluting the witness statement with the actual video.
So what exactly did she say to you?
She stated she went outside individual that appeared to be Mr. Millete standing next to the fire. It appeared to be for the purposes of destruction rather than recreational usage, and that she then took a video of it 2 hours later, and that's the video that she provided to me.
How did she know what Mr. Millete was intending to do?
I don't believe she described she described what the fire like to her.
How large was the fire?
Counsel, there's an exhibit. I'm going to let the exhibit speak for itself.
I think Your Honor, exhibit just shows light, but it doesn't show the fire.
You can ask estimate of the height of the fire.
Did the neighbor, Miss Trudeau, give an estimate how large the fire was?
I did not get in a height estimate. However, I got that it was a very large fire, which would not be indicative of rectal usage.
And that was your conclusion or the witness's conclusion?
That was the statement provided to me.
During that incident, did she tell you how many hours the fire existed?
No, she provided me with the video that she did.
She captured the fire from the point of its beginning until the end.
She captured the 33-second clip of the fire.
Stated that children's voices were heard at Mr. Millete's backyard.
I did not state that. My statement was that the witness recorded video surveillance that captured children's voices whom she recognized as the Millete children.
And did she tell you if she heard the Millete children in the backyard? That
Yes,
she hear the Millete children play in the backyard.
I guess she stated that she recognized their voices from hearing them on previous occasions.
Was it one occasion or?
Occasions, plural.
Isn't it true that Ms. Trudeau also stated that she did not see anything abnormal at the Millete backyard on January 7, 2021?
Are you asking if she was in her backyard looking into their yard at that date?
Yes.
No, she said she observed the incidents on her video surveillance camera after the fact.
Okay. Did you speak to other witnesses that also heard the fire at the back of the Millete residence besides Ms. Trudeau?
I personally did not. She's the only one I spoke to.
And in fact, the other witnesses that the Chula Vista police officer interviewed did not see what Ms. Trudeau saw.
Objection
Is that
vague
right?
and lack of foundation.
Counsel, you're asking him what other witnesses said. Can you give me an offer of proof that he is aware of what these other witnesses said?
Well,
that he has personal knowledge?
I believe that the detective was aware of what was going on that evening of January 7, 2021. And that there are reports that was available to him that I believe he discussed that January 7, 2021 events and the chronology of what happened, the car parking and so forth. So And he also stated that he obtained other information from the other officers that he considered in preparing his reports.
Mr. Rose, did you speak with any other witnesses regarding this incident?
This particular incident regarding the fire? No, I did not.
And have you had a discussion with the officers who wrote the other reports regarding?
I did not.
Lack of foundation sustained.
Okay.
Calls for hearsay.
Now, you made a report in reference to the vehicles that were in the vicinity of the residence on January 7th, 2021, in the early morning, going on to January 2021.
This appears to be beyond the scope of his direct examination. Was there any testimony regarding vehicles?
I think we spoke about the vehicle.
I don't recall asking about that.
Only the Lexus, Your Honor.
Same scope, inquire officers, but not others.
Oh, I think I'm referring to his report on it's 01591 during the cell tower search of the.
He's written a lot of reports. And
Yeah.
we did not go over all of them on direct.
So I am limiting.
I'm moving from one incident to the other, and I just wanted to make sure that I cover what he covered on direct. I don't want to go beyond the direct examination.
I know when you go beyond the direct examination because I'm taking notes. Listen.
Okay. You covered a lot of report regarding the spellcasters that Mr. Millete contacted in 2020 up to 2021.
Correct.
Okay. In fact, on January 13th, 2020, obtained consent from Larry to conduct forensic examination of his cell phone. Is that the same cell phone that you used in your analysis?
I used a lot of information. That is one piece of it, yes.
And Mr. Millete cooperated and did not object to the officers obtaining that information.
That would be accurate. However, it is likely he did not know that that information was still retained on the phone.
I'll strike that for the last part of his response because it does call for speculation.
Your Honor, I was basing that off of the Google return as well.
I'll still strike.
Okay.
The first part remains.
Okay. As a result of your investigation on the spellcasters, you know that Mr. Millete obtained those information on the spellcast to the internet.
Objection calls for speculation. Or vague. Being asked.
Your Honor,
Okay. He either learned about it because someone told him about it in person, or you did discover it over the internet.
I'm not entirely sure what the relevance is either way, but so making a section relevance.
Well, I've already sustained one objection. It's gotta be sustained.
Sorry, Your Honor, it's just this thing to stick.
Come on, Benita, get it together.
on September 30, 21, this Millete ordered a spell. He would go and email the order to the internet to the spellcaster. Is that what you discovered when you looked at the subpoenas? Calastrology.
I you got the year wrong. You said 2021.
This is, let me look at the order, Jan.
And if there's an
September 30, 2020.
So there's over 1,700 pages of spell communication, and we only touched on a here in the exhibits. There's different styles of communication. You'd have to refer me to the exact exhibit and which format you're referring to.
Actually, all I'm trying to understand is if Mr. Miller ordered the internet or used the internet to order the spells. Did he do that?
Yes, it's a web-based service.
So, things that he in fact sent to the spellcasters will be transmitted electronically to the spellcasters.
That's how email and the internet works, yes.
And if he wanted to have the spellcasters harm Mrs. Millete, that would be recorded into the email and sent to the internet, to the spellcaster.
His requests are requesting service form to have those events come true. Yes, that's.
Did they come true?
Well,
That's
Okay. I withdraw the question, Your Honor.
that's
I withdraw the
legal, that's a
question.
legal and factual impossibility. Let's see what the spells were. That's irrelevant.
You know that there are hundreds of spells he requested. Throughout those requests, did you ever read from what you subpoenaed that Mr. Millete requested that Miss Millete disappear?
well, if you're referring to the exact word disappear, no, that wasn't used. There were certain instances where he was requesting services for death magic, where it wasn't explicitly described who he was referring to requesting those services for. And I think we just showed in the exhibits just a snippet of the kind of harm that was being requested in those spells.
In fact, the general or the essence of his request also included for Mrs. Millete to love him again, right?
In the sense of being a subservient wife that does everything he's asking, yes.
And that he expressed his intent to the spellcasters that all he wanted is really for his wife to be at home with him and the kids. And that is the general theme of all those contacts with the spellcaster.
I would describe that as inaccurate.
So let
The
me
general theme of these spell quests are control, and for the under individual to do a wide range of things that were basically subservient and obeying general essence. And then, the spells are basically to control an individual's will to prevent her from leaving him.
And I think you can move on from,
okay, Joanna.
from that area.
Yeah, I don't want to go through all those spells, Joanna. I think I just wanted to see the general theme or express towards the end of the spellcaster's role in this event. You testified that Mr. Millete terminated the spells on Miss Millete.
That would be correct. January 9th is when he sends an email requesting that the hexes stop for May and begin on another individual. And this is prior to her being reported missing.
Now, you talked about the sex tapes that were discovered in Lara May's computer.
All right. I
Uh,
and I don't think it's relevant now.
I'll,
Prove as to why it's
it's relevant to show, Your Honor, that Miss Millete, in spite of all of what is contained in the requests to the spellcasters and the hexing and allegations of Miss Millete's unfaithfulness, they actually,
I'm going to interrupt. I think it was Mr. Grinley who testified. Or were you? Okay.
let me just finish what I was trying to do.
So,
Okay.
didn't testify. Got your opportunity with the other ones.
Mr. Rose, was there any attempt from Mr. Millete to hide any of this information to the spellcasters? Did he request to make it confidential or private?
Well, as I previously testified to, the Google return did not contain these emails which were located on the phone. So they had been removed from the Google account.
Now let's go into this job that you did concerning the infotainment system on the Lexus. Do you recall that?
Yes, I recall the infotainment system.
Okay. You, in fact, testified as to the data or information that you gathered in order to determine the distance that was traveled by Mr. Millete on January 8th, 2021? Is that right?
The testimony I described regarding the infotainment system was in relation to the GPS entry point at 3:29 p.m. on January 2021.
And in fact, the GPS system was not working when you first looked at it.
That would be inaccurate. I could not tell you if the system was working at the time because based off of different models of infotainment systems, they store and retain different information at different rates.
And you would not have the ability to determine whether the GPS was actually working or not.
I can tell you that the waypoints were not something that system particularly documented, so it would not be retained on the system.
Okay. How did you account to the history of what vehicle did Mr. Millete and Mrs. Millete use during that time frame? I believe it was September, or was it December 17 until January 2021?
December 17th, 2020 to January 23rd, 2021.
Yes.
The mileage analysis factors in at the 444 mile number. That would be given that the Lexus was used the most amount of possible times during that period. So it is possible that the Lexus was used less during that time, which is why there's a mileage range up to the 600 number that I mentioned. So the analysis factors in that 444 miles being if the Lexus was used the most amount of times possible during that period.
In all of your calculations regarding the mileage, they were all estimates, right?
The exact mileage estimate?
Yes.
Yes, it's going to be an estimate on the exact mileage. However, it's going to be approximately the same from one distance to another.
If Mr. Millete used the Lexus on January 8, 2021, and he traveled, in your first calculation, I believe it's 446 miles that are missing.
That would be if the Lexus was used the most amount of times between December 7th, 2020 and January 23rd, 2021, there would still be approximately 444 miles unaccounted for on January 8th.
And what date did you use for this appearance date?
To this analysis. Well,
Does the disappearance date factor into your analysis?
Well, there's no records of her on or after January 8th, so you would be unable to factor in her movement. However, the Lexus is accounted for during those times.
So if Mr. Millete's Lexus was used by someone else, like his father, you would not be able to determine who would be driving the Lexus during those target dates, correct?
Which target dates are you referring to particularly?
The range, the December 17th through.
Well, there's certain time periods where I believe that his parents were not there. And then following the January 8th, 2021, there is much more limited movement from the parties at that residence. And I have not done an in-depth analysis on the parents' phone numbers.
Mr. Millete's parents left Paseo Los Gatos on December 20, 2020.
A youth council.
Excuse me.
That appears to be a fact, not an evidence.
Oh, okay.
This witness has personal knowledge of that.
Do you know the date that Mr. and Mrs. Benito Millete?
No, I do not.
Do you know the dates? Or do you know the date when they returned to Paseo Los Gatos?
I do not recall exactly.
So if you did not know who else might be using the Lexus during those target dates, what effect would that have on your analysis?
Well, if you could provide evidence of the Lexus moving during those time periods, I could account for additional mileage. However, I know that the family had 4 vehicles and the parents had their own vehicle as well.
You also said you cross-referenced the movement of the vehicle with ATM transactions, things of that nature.
Yes, financial records. I provided a very lengthy mapping and documentation of sources.
And that included whether it was Mr. Millete.
So for the analysis, I documented both May and Larry Milliete's movements. For factoring in that 444 number, it's whoever, if they were both moving at the same time, I factored in the most distance at that time. So there was always the most distance being factored into that analysis.
Did you find any financial records for Mr. Millete on January 8th?
There were no credit card usages from the Navy Federal Credit Union, no.
On the second analysis that you did calculate on the mileage, I believe it's 1,300 or so that are missing that you cannot account for.
I have to refer my notes for the specific number between those dates.
Oh, please do.
Would be 1,379.
Okay. What is the difference between the 446 and 1,379?
The 1,379 is how many miles the vehicle traveled in total from December 7th, 2020, January 23rd, 2021. The 444 to 600 and something miles is the mileage I can't account for any other day. So on January 8th is the only day where there's movement I can't account for. That would be that day.
Okay, thank you. That's all I have, Jan.
Redirect. Right. 44 miles is the most, but then you list a number that's over 600 miles.
So up to 670, something like that. That would be if he used one of the other 3 vehicles, or if they used one of the other 3 vehicles and not the Lexus. So there could be additional mileage that was not accounted for.
Redirect.
I have no additional questions.
Maybe with this excuse.
Yes.
So, with your testimony.
Thank you.
Additional witnesses or evidence?
No, Your Honor. Subject to moving my exhibits into evidence, we will rest.
Does the defense wish to present any affirmative evidence?
No,
All right, then, let's address your exhibits. And I have the exhibit list that my clerk has prepared. And I guess the question is, Ellen, are there any exhibits that have marked but not identified?
There are 2 that I'm going to withdraw because I chose just not to call those that were relevant to those exhibits. So I would move to withdraw exhibit 24 and exhibit 39. They were not discussed or
24 and 20 council.
24 and 39.
On 39, okay.
24 and 39 withdrawn.
Yes. And otherwise, I would work to receive into evidence all of the people's court's exhibits.
And, yeah, I'm sorry. I was hearing two people at once. With the exception of 24 and 39, everything has been introduced.
Yes.
Or has been offered. Okay, all right then. Is there any objection to admission of courts 1 through 23, 25 through 38, and 40 through 41 through 47?
I believe it's 47.
Any objection?
No, yeah.
Right there. Those exhibits are admitted into evidence. And I'll address the media requests regarding redacted documents after I make my ruling. Argument.
Thank you, Your Honor. I want to cite a couple of cases because obviously this is a unique case. The fact, this is citing People versus Manson, a 1977 case, 71 Cal App 3rd, 1 at page 42. The fact that a murderer may successfully dispose does not entitle him to avoid prosecution. This is one form of success for which society has no reward. Production of the body is not conditioned precedent to the prosecution for murder. That same citation for the additional cite, the fact that the victim's body was never recovered is in itself circumstantial evidence that supports an inference that death was caused by criminal means. This is because it is highly unlikely will successfully dispose of her own body. There's another case, Epperly versus Commonwealth, a 1982 case, 224. This is the Virginia case, 214, but has, I think, relevant language.
Can you spell that?
Epperly, Epperly. And that is, again, from 1982, which this 1982 case cites to the proposition that worldwide communication and travel today are so facile that a jury may properly take into account the unlikelihood that an absent person, in view of their health, habits, disposition, and personal relationships, would voluntarily flee or, quote, go underground and remain out of touch with family and friends. The unlikelihood of such a voluntary disappearance is circumstantial evidence entitled to weight equal to that of bloodstains and concealment of evidence. I am required to prove, obviously the court is aware of the standard of proof at a preliminary hearing by probable cause, that Millete is no longer living and that her death can be attributed to another person's unlawful conduct, not an accident, not suicide, and in this case, the defendant's conduct. We have heard substantial evidence about the fact that Millete's life essentially ended after January the 7th. There is no proof of life for Millete after that date. The last communication to her sister Jane on her Facebook account was at 8:15 p.m. The last Google search was for a motorcycle at 8:45 p.m. There is no evidence from the multitude of search warrant returns from Apple, Google, Yahoo, any communication from Millete after January 7th. No one sees or hears from her after January 7th, 2021. There's no evidence that she worked on January 8th, 2021. She has had no contact with her children, with her employer, with her friends, all of whom she communicated with on a daily basis. There is an absence of evidence that she was suicidal, was hurt in an accident, or died a natural death. There's no evidence that she is in jail, was located in the ME's office, hospitals, or any local hotels. And it cannot be understated that there's significant evidence of May's love for her children and her commitment to her children, and that every decision she was making in 2020 was centered around the impact that a divorce would have on her children. She, in a screenshot of messages that we saw on the Instagram account for the Sailor Moon account, she told the defendant, "I'm only here for the kids." She adored her children, and the photographs speak for themselves. Even Blaine Hinckley, who had just met May Millete, identified the bond that she had with her children, and in a Facebook post that was connected to a photo of May with her children laughing as they drove on a Jeep run, said, "You captured the best essence of life, unfiltered fun and love. Your daughters are having pure fun with you." We also know that she was worried about her children. We heard from Christine Timmers, who said that May Millete, who was not an emotional person, cried when she told her friends that she was worried about what the defendant would do, that he may hurt the children to hurt her. He was so desperate that May Millete not divorce him. They were her world, and she would not have abandoned them, and that is clear. We had evidence that she had no financial means to essentially run away and disappear from her life. In fact, going back to the quotation from the citation and substance of that Epperly case, that is from 1982, discussing that worldwide communication and travel make it difficult to believe that anyone could simply disappear from their life. And it is even more so now with the multitude of surveillance footage, cameras, and connectivity throughout the world. There is no evidence that she left the house after the video surveillance shows her walking into the house on January 7th, 2021, just before 5:00 p.m. And we have evidence that her cell phone terminated all connection to the network at 1:25 in the morning on January 8th, 2021. And it was consistent with being at the residence 2413 Paseo Los Gatos. We also had significant evidence of May's state of mind leading up to January 7th, 2021, and it is very clear that she was committed to filing for a divorce. Not only was she committed to filing for divorce, she was committed to spending the weekend in Big Bear for her daughter's birthday. We saw surveillance video of her cleaning out the Jeep, getting it ready for the trip that they would be taking the following day. There was luggage at the residence, and if you look, there was a screenshot of the that was introduced into evidence from the officers when they first got there, January the 10th, and in that way is the same piece of luggage that was discovered October 19th, 2021, that had cold weather clothes inside of it. So indicated that she was packed and ready to go to Big Bear. She was packing and getting ready for Big Bear at the same time she was looking to file for divorce, and specifically wanted to wait till after the weekend for her daughter's birthday. And going back to the first day of testimony, we heard from Destiny Johnson, who gave very compelling testimony about how, and again, someone who had just not even met her.
I love it.
spoken to
You
her
guys
over the
blow
phone,
up the chat.
who
Justice
heard in
for
her
May.
voice how
She's going to
excited
get
she was
justice,
to
you
spend the
guys.
weekend with her children, celebrating her daughter's birthday. On top of all of that evidence, we have evidence of the defendant's motive to prevent May Millete from divorcing him and restoration. We have messages that he exchanged with Ms. Talanza. We have evidence that he had a desperate mindset to track his wife, put the children's phones in her car to make sure he could track her at all times. And he did not want to share custody of the kids. And what a divorce would mean would be sharing custody of the kids. And he told Genesis on September 23rd, I told her my intent is for her to lose her job and I get 100% custody of the kids. I don't want to share custody. I just want the kids. And then we have very compelling state of mind evidence that frankly is more unique than any case I've seen, where the defendant is admitting to these spellcasters that, again, the only reason his wife hasn't left him is because he threatened to go to her command. He had taken all steps to humiliate her, ruin her, and shame her, and that had failed. He had no other option, and that afternoon, we have messages where he is saying, I'm about to lose it. I'm shaking inside, ready to snap. And then, January 8th, we found. We see the reasoning of Alexis in the driveway, the garage, to load what he says is trail mix and tangerines. And that day, his phone is off for 12 hours, which is inconsistent with his historical activity. And his boss can't find him. He's not shown up for work. And I want to point out, because this wasn't in the exhibits, we have Courts Exhibit 11, which are the screenshots of Terry Fonville's text messages. And then we also have Courts 30, which are the SMS messages that were obtained via the T-Mobile warrant. And the court may notice that there are messages in the screenshots of Terry Fonville, one of the defendant's close confidants, that are not present on the screenshots. So in other words, the screenshots of the messages on his particular phone don't contain the messages that we learned about through the SMS, the T-Mobile record return, that contain actually a message on January the 7th, I'm about to lose it. In addition to some screenshots of messages that Millete was sending to the defendant, and the defendant was screenshotting or sending copies of those messages to Terry Fonville. Those also are in the SMS, the T-Mobile records. They are not on Terry Fonville's, in the screenshots of his text messages. And we have evidence of the defendant sending screenshots or excerpts from text messages that Millete was sending to him. And so we know there was text message exchanges between the defendant and Millete that week. Specifically, January 6th at 10:03 a.m., there's a screenshot of messages from May's text. I should have left a long time ago, and this time I'm not going to look back and say that again. That was in the SMS, the T-Mobile records for Terry Fonville, not on his phone, not on the screenshots the detective took on his actual phone device. And then in two of the different spell exhibits, 27-67 and 27-71, that same language, I should have left a long time ago, and this time I'm not going to look back and say that again. It's exhibits to the spellcasters, which just indicates that the defendant deleted all of his messages only with his wife, Millete, prior to January 2001, which is guilt. And then, as the court is aware, a significant change in behavior, activity, mindset, in that on January 9th, he now has shifted his focus to the person he believes is responsible for the demise of his marriage, and he no longer wants to hex or gain control over his wife, which he's been obsessed with the entire previous year. Millete did not just fall off the face of the earth. She lived for and adored her children. She would not and did not leave voluntarily her children. She loved them, Lara, Melanie, and Lazarus, with her heart. There is no evidence of anyone else having any animosity towards her. She loved her family, her children, her friends, her career, and her life. And she had every intention of living and continuing to live after January 7th, 2021. The only person who had a motive, who spoke of the desire to hurt her, is the defendant. And I would submit, Your Honor, that there is more than enough evidence at this point to hold him to answer at trial for these charges. And with regard to the assault weapon, I'll address any question about that. I think that was fairly clear from Agent Paradis with regard to his testimony regarding count 2. I'll submit on that.
Thank you. We're going to take a 15-minute recess. We'll resume at 11:05. Now I'll hear your argument.
So I guess it's break time.
Back in session. Back on the record, counsel and the defendant are present. You may give your closing argument now.
Thank you, Your Honor. Your Honor, it is a common belief there is no body, that there is some mystery about the disappearance of May Millete on or about. They don't even know, Your Honor. They said it's either January 7, 2021 or into January 8, 2021. They themselves don't know when exactly, what time, what date, how did she die. They didn't tell you. As of May Millete's mysterious disappearance, much speculation developed, and the people complained and charged him, and all these complaints really heavily relied on circumstantial evidence. Even with all the elaborate apparatus of modern publicity, media, Facebook, internet, what have you, and multiple agency efforts in locating a body has not been successful. This could mean that they should be looking for Maya among the living and not among the dead. Larry and May Millete had a strong relationship until she started having marriage problems, until she had a relationship with another man. Her sister told you that. That is the beginning of her problem. Not only that, she turned to excessive alcohol consumption. Perhaps at the beginning she wasn't drinking very much, but in 2020, that habit seemed to be increasing.
So what is the relevance
It added to her problems, Your Honor. She wanted to live a single lifestyle, going with her friends, going out at night, not taking care of the children. After 20 years of marriage, there is a change in her personality. And that, in fact, was a problem. When Mr. Millete saw these changes, he became hyperactive and wanted to know what's going on. He didn't do any action until there is a report from someone reporting Miss Millete's behavior or affair to her supervisor or to the authorities at SWARMAC. Everything that he didn't start that. Mr. Millete didn't start the problem. It is Miss Millete who started the problem because of her relationship and her affair. If we look back at what happened, he was suspecting that Miss Millete was having some abnormal type of actions, and he's tormented about that. But he couldn't pinpoint what was going on with her. So he was watching, was calling her, was trying to find out. He asked Miss Millete if what's going on. She denied it. Even during the investigation, Miss Millete and Jamie lied to the authorities, lied to Mr. So, her supervisor, lied to the NCIS, and we lied to Mr. Millete because it would have been so easy if they admitted it at the beginning. He didn't have to act like try to follow her, call her, And she got aggravated because he's trying to call her too many times. But what kind of reaction would you expect from a man who now has this knowledge that someone in the office, in his office, was now reporting about this? Obviously, he would be tormented, upset. So after that happened, voluntarily transferred to another division. He did not harass her to do that. Miss Millete voluntarily transferred. But Mr. Millete did request Mr. So to move this person that was having an affair. I don't see anything wrong with that. He was trying to remedy the situation. He's getting frustrated. What else did he do? Okay, so he started asking Miss Millete's family, please help. Ask everyone, every member of the family. He didn't have any choice. He had to reveal them what the problem was supposed to be. So the family, what they say, Miss Millete's family said, we can't help you. We talked to her already, and she said she can handle you. And she doesn't want us to interfere in her relationship. So what can he do? Now, Miss Millete got angry because her husband was telling the family about her. She didn't like that. But the family asked Miss Millete if the affair was true or not. Miss Millete denied it. She denied it to the entire family. So what would the family say? You're not, we talked to her, she said it never happened. The same thing with Miss Millete's friend. She kept it, the affair was kept a secret from everybody. But if she was just honest to come out and accept the fact that she was having an affair with this person, it would not have gone that she would have to resign, she would have to move, and the fights continued. Obviously, the fights would continue because she's still denying the affair, the relationship. So then,
She also said she just wanted a divorce.
right,
Why couldn't he just accept?
she wanted the divorce. He didn't like it. He didn't want the divorce. He believed 20 years there was nothing wrong with that. He remembered the promises that they had, and it's against his religion. He didn't believe in divorce. His family didn't divorce. So he even went to a pastor. I mean, he tried every avenue that he knew about. What else did he do? He bought her everything she wanted. She wanted a Jeep, he gave it to her. Everything that she wanted. She wanted to go on vacation, trips, shopping, $700, $1,000 shoes in one day. He did not try to stop her in what she wanted, except that one thing, he is not going to allow her to go and continue having this affair. So what happened? One day, he discovered them together. He did not snap. He did not curse that man who was with his wife. He just simply asked, what are you doing here with my wife? He's calm. He didn't jump into any conclusion. And so what happened? Mrs. Millete then started crying and confessing to him. For the first time, she admits to him the affair. right there. What's his reaction? He did not snap. He went on to help her go back to where she was staying with Genesis and JR, help her pack her belongings, took her back into their house at Paseo Los Gatos. He didn't strike her, he didn't do anything violent, and with open arms, he took her back. They promised to go to counseling. They did. However, counseling didn't work. Why? Because Miss Millete continued to have the affair with Jamie. She didn't stop, but Mr. Millete didn't know that. She came back and resumed the affair with Miss Jamie, while Mr. Millete was trying to do everything he could to show to his wife how much he loves her. You heard from all of these witnesses from the Avalanche family to Miss Millete's friends, they never observed or witnessed any physical violence during all the time that they know both of them. Not one of the family members or the friends told you that they have seen Mr. Millete harm his wife. The only thing that they know and remember, he repeatedly told all of them how much he loves his wife. In fact, Miss Millete wrote this letter dated August 29, 2020, when they were together. She said, "Dear Larry, you are right. You are right," he wrote. That's the first sentence. "I am not myself anymore. I've turned into this bitter, angry person who is careless with her words." She admits that Larry is right. Well, of course, Larry didn't do anything wrong. He was not the one who is unfaithful. He's not the one who's cheating. So, but a reaction from a husband to try to follow what your wife is doing each day wouldn't be abnormal if you are in his shoes. Maybe other men would even have a different reaction, maybe violence. But no, he's still calm. So what happened? They resumed the relationship as husband and wife. But I can see the problem more clearly. Miss Millette was not happy with what was going on in her life. Her work was her priority and identity. She moved out very much. In fact, she often stated that her work is her identity. Then when she moved to another department, it didn't work very well. She may have been good at the very beginning, but as the days and months went on, her supervisor said, "Mr. Mansfield, her work product is suffering." That is a problem for her because now Mr. Mansfield wants to talk to her about her work product. At that time, COVID was in the air, and Miss Millete was working at home. Mr. Millete, though, had to go to work at a hospital. So Miss Millete is at home with the children. But what did she do? She didn't take care of the children. There's no issue there. She can't deny that. Miss Millete cannot deny that because they were physically present in their home. So some of the relatives came and go and stayed with him some time. It was just a normal family, but there is still that some sort of a problem between Miss Millete's family and Larry's family. There seems to be some problem there, which is not very clear yet until we hear that Miss Millete did something or planned something in order for Larry's parents to be out of the house. Then when they left in December, everything became chaotic. The house was very dirty. There's nobody cooking for the kids. Now this problem is spiraling, increasing because they needed childcare. That's the big problem. They were fighting about that. They were not only fighting about Miss Millete's parents to come in and babysit and take care of the kids. They were fighting about scheduling, who's going to do this, what's going to happen. It's not only the affair because Mr. Millete did not know that Miss Millete was continuing to see Jamie. So one day, he finds out that they were still doing the same thing. So what does he do? He calls Jamie and tells Jamie. Still, he did not go and attack Jamie. He did not go and confront Jamie physically. But what did he do? He called Jamie's wife. And they spoke. And Jamie's wife, now hearing about the affair, calls Mrs. Millete and talks to her.
I don't know if those were vaccinated.
There were a lot of facts, not.
I believe they spoke around January 2020. Then so now Miss Millete is really having this terrific pressure. What does she do? She calls and looks for a divorce lawyer. She found one and she wanted to go and see the divorce lawyer. However, she kept it a secret from Mr. Millete. She didn't tell him that she set an appointment. Okay, so that
Objection, that states facts, not in evidence, and
she,
speculative.
well, she told the intake person from the Broden Law Group. She said, I don't want to go there physically because he might follow me and, it would mean trouble. So she said, I'm just going to do the consult over the phone. But there is something really, really puzzling about that phone call. This statement was saying about if something happens to me, it's Larry, or you always, meaning Mr. Millete, you always wish for me to die, or you wish death on me always. It's really very strange. You're now talking to Broden personnel, and you don't tell that pieces of information that would have been so important. And you heard from Ms. Johnson. That was not stated when she had consult, because Ms. Johnson was in fact telling Ms. Millete, I think you should come next tomorrow because we must do a restraint. No, Ms. Millete doesn't want to do it right away. She wanted to wait. So it didn't worry her at all. Now, with all that going on, with all the pressure on January 7th, with all the collapsing of her world, problems with the embarrassment that she had, the humiliation, the sworn at. Now the problem with NIWC with her work product. Also now there's no child care. There is now fighting between the two of them. The house is chaotic state. What else? Mr. Millete told her, I'm going to reopen an internal affairs investigation. What does Mrs. Millete do? Given that statement from Mr. Millete, he now calls format Mr. So, her former boss. Why? Why would you call your former boss? She told him Mr. Millete was threatening an internal affairs investigation. She alerted Mr. So why alert him? In addition, Ms. Millete believed that if Mr. Millete is going to report the affair, it will be discovered that Jamie is Millete lying. So she was in a tight spot. She has to disappear. She has problems with divorcing him because if she divorces him, what will happen? They can't. She can't pay. She was making more money than Mr. Millete. Mr. Millete was working very hard, work overtime to meet all these expenses. Her world is collapsing. Mrs. Millete has to go away. What happens? She calls Jamie. She talked to Jamie on January 7th, 2021.
Objection assumes arguing facts, not in evidence.
I believe that was it.
Sustained.
Then she locks herself after the argument. She locks herself in her bedroom. In fact, she had kicked out Mr. Millete already. This man had taken so much beating from Miss Millete. And his reaction? He cooks food for her and brings it up to her in her room. He does everything for her. Buys her the jeep in November, when in fact Miss Millete already said, I don't want you. I don't want you to be my husband. I want a divorce. I want separation. He still buys a jeep for her and get himself in debt. So now it's Mr. Millete believed he did everything he could. In order to cope, he had to do something. He talked to Genesis. Genesis and Mr. Millete were
I want you to push this.
okay.
And Ms. Bowles needs to give a rebuttal and I
Well,
have to make my ruling.
I know, Yana. I know. Let me just add this fact that was presented to you. They're alleging that they didn't see they the rest, that there is possible exits at the back and all of that. You also heard about the two vehicles that parked there. Possible that somebody was waiting for Miss Millete to come out and, because that vehicle was there parked for over 2 hours. So as far as Mr. Millete knows, there was an argument on the 7th. There was a complaint from Mrs. Millete that she couldn't do any work because Lazarus was bothering her and they didn't have a caregiver. So Mr. Millete took Lazarus very early in the morning to the beach and they were there the whole day. They came back. He took care of his child and took care of the children at home. He didn't find out that Miss Millete was not in the house until the door she wasn't there. He can tell you he loves his wife very much and he did not kill her.
Ms. Bowles?
Your Honor, I will to the court, and the court was taking copious notes throughout the hearing, so I will not go through the multitude of facts that I believe were misstated in Ms. Martinez's argument. I only want to highlight a few, which are that there is absolutely no evidence that May Millete was engaged in excessive alcohol use in 2020. There's no evidence that she was not taking care of children. In fact, evidence that that was, as I stated before, the August 27th letter read contained the statement about her having changed, that she said, but that's what our marriage has turned me into, and I hate it. I hate that you get me so angry all the time, and you speak so righteous while I speak so bitterly. And she goes on to say, anytime I'm outside the house and not within your view, we are fighting. It's unhealthy and toxic. We need to change, but with the kids in mind. She states she wants to be happy. And so what does she do throughout the remainder of the year? She takes steps to become a more independent person, independent from the defendant. And the more she pulled away, the more independent she became, the more she was not subservient to him and allowing him to track her every movement, the more obsessive he got. She stated in one of her diary entries that was read that she was finally going to fight for me. She was no longer going to be a serious wife. She finally had found the courage and the strength to leave her marriage and finally took those steps to do it. And I think the last quote of that one entry is, "It's time to take back my home." And that was her intention, and it was the defendant's intention to stop that from happening. She was not going to divorce him. She was not going to leave him with 50% custody or a reduced amount of custody with the children. They were his entire life. He was obsessed with her. They're maintaining their family as a family unit. And when that was threatened, he had to take the action that he did. They were never going to be divorced, and he made sure that that happened. And again, I would submit to you, again, the court has listened to 9 days of testimony and has obviously seen all the exhibits. So I will submit to the court that, again, there is more than enough probable cause to find a court for trial.
The purpose of a preliminary hearing is to determine whether a defendant charged with a felony should be held for trial. There are several burdens of proof under the law. There's proof beyond a reasonable doubt to sustain a conviction for trial, clear and convincing evidence for civil, juvenile, and family court findings, preponderance of the evidence for civil findings and criminal motions. And finally, there's the probable cause findings for preliminary hearings. This hearing requires the lowest burden of proof standard under the law. Penal Code Section 872 states that if it appears from the examination of a public officer, Penal Code Section 872 states that if it appears from the examination that a public offense has been committed and there is sufficient cause to believe that the defendant is guilty, the magistrate shall order that the defendant be held to answer for the charges. The term sufficient cause is generally equivalent to reasonable and probable cause. That is, such a state of facts as would lead a person of ordinary caution to believe, conscientiously entertain a strong suspicion of the guilt of the accused. This case presents a scenario from most cases because the victim's body has not been located. However, this is certainly not the first time homicide charges have been filed against a defendant where no body was found. There is U.S. and California case law dating back more than a century that addresses this issue and provides guidance to the court. And Ms. Bowles, you cited some cases regarding that, but the court has found other cases. For example, People versus Weaver, 2001, 26 Cal 4th, 876, held that causation by a criminal agency may be inferable from the suspicious circumstances surrounding the victim's disappearance. There are two cases called People versus Scott. The first one I'm going to cite is from 1969. People versus Scott, 274 Cal App 2nd, 905, ruled that the corpus delicti of murder consists of two elements: the death of the alleged victim and the existence of some criminal agency as the cause, either or both of which may be proved circumstantially or inferentially. Cases have held that a slight or prima facie showing is sufficient for the prosecution to establish guilt and to satisfy the corpus delicti requirement. Further, production of the body of the missing person or of evidence of the means used to produce death are not essential to the establishment of corpus delicti or to sustain a murder conviction. People versus Johnson, 1991, 233 Cal App 3rd, 425 held. The prosecutor is not required to establish the corpus delicti by proof as clear and convincing as is necessary to establish the fact of guilt. Rather, slight or prima facie proof is sufficient for this purpose. To meet the foundational test, the prosecution need not eliminate all inferences tending to show a non-criminal cause of death. Instead, the foundation may be laid by the introduction of evidence that creates a reasonable inference that the death could have been caused by a criminal agency, even in the presence of an equally plausible non-criminal explanation of the event. This case of People versus Johnson actually provides some good guidance to the court, and I'm going to cite from the text of People versus Johnson at 439. First, the circumstances of that victim's disappearance suggest that she did not voluntarily leave. She had gone to work that morning and returned home to change into proper working attire. After changing, she left and was never seen again. The victim in the case of Johnson left behind such important items as her wallet containing a driver's license, social security card, check cashing card, Jimco department store membership card, a letter informing her of her GED test score, her nursing certificate, an employment registration card, educational transcripts, and letters from her grandmother and sister. The court wrote, "It seems unlikely that having taken the trouble to conform her dress to the requirements of her job, that victim left home and such significant personal belongings only to run away." Further reading from the Johnson opinion. Second, the fact that after her disappearance, that victim never contacted members of her family with whom she had fairly close relationships tends to establish that she did not leave home willingly. The record in Johnson showed that before her disappearance, that victim had regular contact with her sister, her brother, and her mother. In addition, that victim corresponded regularly with a grandmother who lived in New Jersey. The victim's sister testified that she visited the victim every weekend up until the time of the victim's disappearance, and that they had a good relationship. The Johnson court stated it was unlikely that that victim, a woman of 19 having such close family ties, would voluntarily disappear without ever resuming contact with relatives. Finally, the Johnson court noted, the record contains evidence that the defendant behaved toward the victim in a violent and possessive manner, and other witnesses testified to arguments between that defendant and that victim. Now, the other case, People versus Scott, similar case of People versus Scott from 1959, 176 Cal App 2nd, 458 from 465 to 487, also had various parallels to this matter. In that case, the victim's body was never recovered. However, the court found that the corpus delicti requirement was met based on facts that are similar to the evidence that has been presented during this preliminary hearing. The Scott court noted that to accept the defense theory that the victim had simply run away, the court would have to find that the victim abandoned a house, significant wealth, numerous close friends, and personal items such as that victim's eyeglasses and dentures. Now, similarly, in the matter before this court, to accept the defense theory of the case, the court would have to be convinced that Ms. Millete abandoned her life, which included 3 young children whom she adored, an ailing mother, siblings with whom she was incredibly close, ownership of $1 million home, a 6-figure income from a thriving professional career, personal savings and wealth in the form of stocks, expensive purses and jewelry, extremely close relationships with friends, and her newly purchased beloved Jeep Wrangler. Further, the reasoning from People versus Johnson is also useful here. The Johnson court noted that the defendant in that case was possessive and violent toward the victim. And just like the victims in Scott and Johnson, Ms. Millete has left behind such important items as her government identification, wallet, and credit cards. The court finds that the corpus delicti requirement has been met for sufficiency of the evidence. Given the sufficiency of the evidence finding, the court will also turn to briefly the defendant's statements. Mr. Millete gave inconsistent statements to Millete statements which the court finds support the prosecution's theory of the case. Additionally, there's a marked contrast in the defendant's actions before Ms. Millete's disappearance and afterward that provides a strong suspicion of his guilt. Based on the evidence adduced during this preliminary hearing, it appears to the court that there is probable cause to believe that the offenses charged in counts 1 and 2 have been committed and that the defendant is guilty thereof. It is therefore ordered that the defendant be bound over for further proceedings in the Superior Court. Immediate arraignment or due course?
Immediate action.
All right, then please arraign him on the complaint that is now deemed the information. Have you received a copy of the complaint that is now deemed the information?
I think she's almost ready.
You have the complaint, you've had it for quite some time. You can provide her with a copy of the complaint and deem the information.
And Your Honor, just in terms of some housekeeping, I had spoken with counsel and Madam Clerk. I had 2 boards marked as Courts Exhibit 45 and 46. They were duplicates of the calendars that we have in evidence, paper copies, courts 31 and 32. They were the calendar months of December 2020 and January 2021. I would just, for the sake of not having to have the court maintain custody of these 2 boards, I would submit a stipulation that I could withdraw essentially these exhibits, and 31 and 32 will act as representations of the 2 boards that we've used during the course of the hearing.
Any objection?
No, Your Honor.
I'll release those 2 exhibits to you.
Should we proceed with the arraignment?
Yes.
Now, we receive a copy of the complaint, and the defendant has the opportunity to look at it. It's the same charges, and
Does his true name appear on the complaint that's now deemed
Yes,
an
Your Honor.
information?
And he's been advised of his constitutional rights and advanced all defenses and pleads not guilty.
The not guilty plea and denial of allegations will be accepted. The defendant's true name is reflected on the information, and he has been advised of his constitution and trial rights.
Thank you, Your Honor.
Sir, you have the right to have your jury trial held within 60 calendar days of today. Do you waive that right and agree to continue the case to the date requested by your attorney?
Yes, Your Honor.
It will show that he has entered a time waiver, and the following future dates are.
There will be a status conference on March 22nd at 8:30 in Department 16 of the South Division, and jury trial on September 13th at 9 a.m. in Department 16 of the South Division, for 10-day proceedings.
I think she maybe had wanted the 14th. Did you want the
I'm sorry,
14th?
Is what 14th?
It's September 14th.
September 14th at 9 a.m. in Department 16 for backup jury trial.
Your Honor, I did want to address one other matter, and I neglected to check on dates with Madam Clerk on this, but I did also want to request that the court revisit the modification to the CPO that was made, I think it was now several months ago, that allowed the children to exchange letters with their father, the defendant, based on the evidence that the court has received in this preliminary hearing and the conduct and mindset of the defendant that's been presented. I would ask that the court reinstate the original protective order that precludes any contact with the children.
And we did discuss that off the record this morning, and you've indicated that there is a guardian ad litem that's been appointed from one of the other courts, and that individual has been ordered to, well, I've made the order that any letters from the defendant are to go through the GAL for them to. And do you have any information for me indicating that he has violated the court order or is expressing information in these letters that would influence the children's testimony? And I'll back up also, I asked you if you believe that they will be witnesses.
Well, I think that they certainly are potential witnesses, given their proximity to the time of what we believe to be the death of their mother, either. And I think there was testimony about, one of the children's statements being very similar to the defendant's. And I would say probably whether or not the letters are indicative of an attempt to persuade the children might be open to interpretation. But I do know that there was some concern about the volume of letters that was being sent to the children by the defendant. So I do think that there is a concern, especially given that we have had testimony about his attempts at manipulation and control, and his influence with the children would be concerning, given the fact that they are witnesses, potential witnesses to testify in this case. So that is the basis of my request at this point.
I'd like to hear from the guardian ad litem regarding the frequency of letters, volume of letters, and whether there has been anything that the guardian finds to be inappropriate discussed in the letters. I think it's important that he have contact with the children, as long as it's not in violation of court order. The limited amount of contact that I put in place, I think is fine, as long as the letters aren't talking about the court or the proceedings or in any way designed to influence the testimony of any of the potential witnesses. So we can have another hearing where we can address it in full, and at that time, when I've heard from the guardian ad litem, I'll make a determination, or the court will make a determination as to whether the criminal protective order should be modified. Do you want to hold it in front of me, or let it take place in South?
Well, I think at this point, probably the court's jurisdiction is back in South Bay. after the bind over. So procedurally,
The case was assigned to me for all purposes when I was supervising it south, but I thought it would have concluded when I was supervising it. So
right.
now
I
it's back. It's fine. I understand now it's back. Supervising Judge Hanley can hear the matter.
And perhaps I can just add it on calendar for Haley to hear, and perhaps he would to hear the request, given that you presided over the preliminary hearing. I'm talking about procedurally. I know at this point we've now set it in Department 14.
16.
I thought for readiness, aren't we in 14?
We weren't.
Oh, I'll
And
address it.
I've talked with Judge Smith and Judge Roche and Judge Hanley, and it may well end up with me for trial, but we'll see. We'll see based on everyone's availability.
Okay. So we'll address, I'll address perhaps calendaring the case then to address the CPO with Department 16.
Correct. And I'm sure you can find time. You can find time in an afternoon to have the court hear it, afternoon or Friday morning. There's flexibility in the schedule. Okay. I understand. Before I order them back, I'll hear from the media in regards to their concerns regarding the exhibits, Mr. Godfreyson. And what I'm going to do is, and I'll note this first, there is a procedure that the Superior Court has regarding the release or copying of any exhibits that have been admitted into evidence. And our public information staff has, I believe, informed you of that procedure today. We have a written copy which we can provide you with. Regardless, my concerns are for privacy interests of the minors and for any adults. I don't want private information or statements by the minors being released to the media. And I want to protect the telephone numbers, addresses, and biostatistic information of any adults. So what the parties have proposed and what the court agrees to do in this regard is a duplicate set of exhibits will be produced by the people, and that will redact private information and faces of the children. And any request by the media for exhibits will be from the redacted version of the exhibits. Any further questions?
Your Honor, we have no objection to the faces of the children being redacted. For 2 years, we've had access to family photographs, and we have voluntarily blurred out their faces. So we have no objection to that. We certainly have no objection to personal identifying information being redacted, such as phone numbers, social security numbers. We understand and we trust the district attorney to act in the public interest and redact only those items that are legally redactable. These records start off with the presumption that they're open. And so the redactions need to be narrowly tailored and limited. And so based on what we have seen displayed in court, we're asking for one exhibit not to be redacted. And that is the exhibit disc number 42, where, and it's a key piece of evidence where May is seen returning to the home. And this is not the camera next door to the house, as Your Honor knows, that shows a closer shot of the children and May driving away and leaving. This is her returning, where that shot is from the end of the street. The same camera that captures Larry Millete backing out. So it's very distant, blurry. The May and the children are seen as small black shadows. And she drives up, and right after she drives up, as Your Honor recalls, a UPS truck drives up and blocks the vision of the camera of the kids exiting the car. So we're requesting that that piece of video, though we may see some small black shadows of things, unidentifiable people roaming around, it doesn't really show identifiable children. And that is such a key piece of evidence because that is the last video of May on the record being seen alive. And the people allege that she never exited the house after that. So the public is interested. I've received text messages, emails from people, why aren't you showing that? And we would like to be able to show that. And given that the children are not identifiable in that video, that's the one piece that we would like to see.
Ms. Bowles, did you wish parties wish to respond? My tentative is if it's at all got the children, I want it blurred. And you can see the vehicle, that would be fine, but I don't want faces being identified. Ms. Bowles,
I'll submit to the court.
can you provide any guidance?
If the children can't be seen in the video, in the segment that they're requesting, then if we were to blur them out, I don't know what the difference is.
Ms. Martinez?
Yeah, it's true that you can't see the faces of the children on that video. But I think that it could be shown if you still block the the images of the children, because they can still see the height and these are the children that belongs to the Millete.
Because I think
My order is going to be that if you have any video of the children, that would be blurred. And that's just a blanket order. I'd rather err on the side of caution. There might be lots of public interest about it, but I am concerned about privacy. And that expresses over public interest.
So just to be clear, the people intend to release that video with some sort of blur on the faces of the children.
no. My understanding is the media is to make a request. These are court's exhibits, so that the media is going to be making a request through the court process to obtain copies of what they believe is available to them.
That is correct. You can talk with them regarding the court policy, but essentially everything that has been admitted into evidence is going to be duplicated but redacted, and your media request will go to the redacted version of the admitted incidents.
Right, so essentially we're sealing the exhibits and the people are producing a redacted version of the exhibits which may be available to the public. So in that one piece of video, the people are redacting that part of the video, right? Just like they're redacting the faces of the kids in all the other exhibits, that one piece of video should be redacted so that the kids' faces can't be seen. Is my understanding correct?
It would appear so. There's going to be a second set, and that second set is what the media request will be based on.
Okay, so we haven't identified everything that's being redacted, but that set of redacted documents may include all the exhibits, and the only thing being redacted is personal identifying information and the faces of the children.
That's correct.
Thank you, Your Honor.
Anything further?
Thank you.
By the party?
No.
The defendant's ordered back to court on the following dates.
Status conference on March 22nd at 8:30 a.m. Department 16 South Division. Back at jury trial September 14, 2023, 9 a.m. Department 16 South Division. And
So there you have it, everyone. Status conference, March 22nd, and trial starting September 14th. And so
Yeah, well, I think once we get a
I'm sure we'll
assigned
be
to our
covering it over here or have
whether it's your honor
someone who will
or
be covering
judge
it. We'll make
Spencer
sure that there's a live
work
stream.
on the motion schedule with the judge that we get assigned to.
That's fine. All prior orders not in conflict remain in full force. That concludes the hearing. Thank you.
I can't imagine that they won't televise it.
Yes.
Well, there you have it, guys. I am so glad to find out that this is going to go to trial. I'm so relieved for May and her family. Um, gosh, it's like a celebration, but it's so sad. I started crying too. And I don't even live in California. I've never met May. I just have followed her story. In all honesty, one of my very best friends could not stop following this story. She just fell in love with May. And so we both watched and here we are. So we'll be back in March. Thanks, everyone.